To our second What If under COVID-19 session. Those of you that are joining us for the first time, I'm Farron, and I'm joined today by my colleague Via.
Hi there.
So today's topic is, what if a job applicant has a comorbidity? May you request disclosure and consider such health condition before making the appointment. I will be taking us through the first half, which is the position prior to COVID-19, and then I'll hand over to Via, who will then take us through what the position is now under COVID-19. Just as a preliminary, we due to time constraints, we probably won't be able to answer any relevant questions during the session, but please feel free to inbox us after, and we will try to answer any relevant questions after the session. Okay, so ideally, employers want to apply a selection criteria in a job which requires that employees or an employee is 100% fit or must have a clean medical history. But in terms of the Employment Equity Act, unless you can show that perfect health is an inherent requirement of the job, such selection criteria may be unfairly discriminatory. A further problem is that questions about a job applicant's health may be an unacceptable invasion of privacy. So therefore, previously it was only acceptable to require the medical history of a job applicant and use such information in the selection of a suitable candidate in the following instances. So first, in the first instance, if an employer could show that perfect health or a minimum level of health is an inherent requirement of the job. And then secondly, where it is a statutory requirement, which may be the case in certain industries. So for instance, for vacant position for a pilot, there's obviously a certain health criteria would be acceptable because of the nature of the job. Similarly, if the job involved working in very dusty conditions, you could be entitled to check on health issues such as asthma or lung disease. So employers should rather ask a job applicant if there's anything which they are aware of which could prevent them from attending work on a regular basis or from meeting the demands of the job. It would then be up to the applicant to reveal any problems, including those related to his or her health. If he or she didn't do so and was later unable to perform the job because of such health reasons, which he deliberately failed to disclose, the employer could then move to terminate his services.
Thank you, Farron. Welcome to all the viewers. I just want to confirm my understanding, Farron. So what you are saying is that prior to COVID, the position was specifically under the Employment Equity Act, is that employers generally, you can only ask a question in the interview to a job applicant with regards to his or her health condition, specifically relevant to our discussion, comorbidities, if that employer can prove that perfect health or a certain level of health is an inherent requirement of the job, one, or two, it is a statutory requirement. Is that correct?
100% correct, Vipia.
All right.
Okay, so Vipia, why don't you now take the viewers through what is the current position under COVID-19?
Sure. All right, I think relevant to our discussion is just unpacking our question. Our question is basically in two parts. The first part is, are you allowed to ask for a disclosure in an interview? In other words, can I ask the job applicant, do you have a comorbidity? And if you are allowed to do that, and this employee has now disclosed that he or she does have a comorbidity, can you consider the fact that the applicant has a comorbidity in the appointment process? In simpler terms, can I say, employee, I'm not appointing you because of your comorbidity? So I think that is what we will be unpacking. I'll start with the first part of the question. I think we need to also consider what has changed. So Farron, you've referred to the Employment Equity Act and the position prior to COVID. So in terms of a regulation or directive point of view, what has changed? And I think the viewers would know that there are various regulations that were published over the last 3 months since the end of March, and specific or of importance to our discussion is level 3 and level 4 regulations, and then the latest consolidated directive or COVID-19 directive on workplace safety. These documents, specifically the directive, requires an employer to do two things. Right? One, you must identify a vulnerable employee. And two, once you've identified this vulnerable employee, you must implement or take special measures to mitigate the risk of this vulnerable employee with specific regards to COVID-19. So those are the two requirements, and the question is, these new requirements, does this change the position, Farron, that you referred to? And the simple answer with regards to the first part of our question, can you ask for a disclosure? It is yes.
Okay. So Vivek, why don't you take the viewers through who are vulnerable employees?
So just vulnerable employees, so I'm going to speak about vulnerable employees and the special measures. Vulnerable employees and special measures are not defined in the directive or regulations. However, I will be referring to a guidance or a guideline issued by the Department of Health on specifically accommodating vulnerable employees throughout our discussion. And this document, I'll just touch on some of the examples. It identifies certain categories of vulnerable employees, which includes, we all know, 60 years and older, which is not relevant to our discussion.
Yeah.
Because in an interview process you would know that the job, or at least you would know the job applicant's age. But of importance is this chronic or underlying chronic conditions that is a vulnerable, or that would classify an employee as vulnerable. It includes chronic lung disease, diabetes, moderate to severe hypertension, serious heart conditions, chronic kidney disease, chronic liver disease. Those are all the chronic conditions that would, fall under, or that if a vulnerable employee has them, they would be deemed vulnerable. But it also includes severe obesity. So you have a body mass index or BMI of 40 or higher. It also includes immunocompromised people because of cancer treatment, maybe a transplant or medication that suppresses or weakens the immune system. Or if you are 20 weeks or more than 20 weeks pregnant, you will be deemed a vulnerable employee. So that's the identification part. With regard to the special measures, I'm sure that would be your follow-up question, Farron.
Yeah, I was just about to ask you, what are the special measures?
So special measures, again, it's not defined in any regulation or the directives. And our view is simply because the reason why it's not defined is you can't have a generic special measure which you apply to all these categories of comorbidities.
Yeah.
You would probably treat a person with hypertension different to another category of vulnerability. So, but again, this guideline does provide us at least with some guidance, and it talks about alternative temporary placement. Obviously, your first prize is working from home, but these are all applicable if the employee can't work from home. So, alternative temporary placement, isolating the employee in a certain area in the workplace, or for example, giving the person a isolated office, giving the person specific protective or PPE.
Yeah.
So not only your cloth mask, but maybe a face shield, maybe a surgical mask. So all of these things, can be limiting the interaction with colleagues, limiting the interaction with clients or members of the public. These are all measures that one can implement.
Yeah.
So with that in mind, Farron, I think that covers the first part of the question. Can you ask the employee or the job applicant at least to disclose? I think the answer is yes, and the reason simply is because these directives and regulation places an obligation on the employer to identify a vulnerable employee, as I said, and then once a person is identified as vulnerable, to implement or adopt these special measures. Now, if you don't ask that question, or ask for the disclosure, there's no way that you can implement these special measures. So that's the first part of the question, which is basically it's quite self-explanatory. But the second part of the question is now the impact this disclosure has on the appointment or the non-appointment, specifically the non-appointment of this person because of the comorbidity. And the focus should again shift back to special measures. So basically, in summary, and I'll explain it in detail now, the reason for the non-appointment is not necessarily going to be the fact that this job applicant has a comorbidity. The question is whether you can or you cannot accommodate this person by implementing special measures. So if you can't adopt or implement or take special measures for this job applicant who is vulnerable, then it would justify not appointing the person. So to explain, just in terms of disclosure, I don't know if I've mentioned this, it is also advisable. We are sitting in, just practically, we're sitting in an interview. I want this to ask the question, it's in the COVID context. I know that legally or in terms of directives and regulations, I need to provide a safe workplace for an employee who has a comorbidity. So I need to ask the question, do you have a comorbidity? Now, it is advisable not to ask the person to disclose the specific comorbidity, but rather to disclose the fact that they have a comorbidity. Now, the viewers might think, okay, but if you don't ask the specific comorbidity, how can you then implement special measures if special measures are not generic, but rather based on the specific comorbidity? Again, the guidance is in terms of this document issued by the Department of Health. It states the following. Once you've identified the vulnerable person or employee, it is recommended that that person is then sent to his or her treating doctor. One would reasonably assume that a person with a chronic condition, person who is pregnant, there is a medical practitioner in the background. So you can easily send that person to his or her treating doctor, and this doctor must tell us a couple of things. One, is the special measures that the employer are currently implementing in the workplace for other employees, is that sufficient for this specific vulnerable person or job applicant? And if it is not, what other recommendations can the or does the doctor make, in terms of special measures? If the doctor comes back and says, employer, the special measures that you are currently have in place is sufficient to cover this job applicant, if that is the case, you'll make the appointment because you are able to comply with the obligation to provide a safe workplace, and your special measures from a different opinion from a third party, a specialist or a medical practitioner, says that it is sufficient. However, if this doctor says, you know what, I think you should also consider A, B, and C, then it does make things a bit tricky.
Yeah.
You as the employer must then consider, can we implement A, B, C, and D? And if you can, again, you'll make the appointment. If you can't implement the special measures as directed or recommended by the doctor, it is then fair and justifiable to then not appoint this person. And our view is, one, again, just to summarize, you can make this inquiry into do you have a comorbidity, but as we said, I think it should not be what specific comorbidity do you have. Do you have one or more of the following? I think that should be the approach, because we know that person will be, in all probability, go to a treating doctor, and that doctor will then give us advice on what we should do as the employer. If you can do it, you appoint. If you can't do it, you don't have to appoint, and the fact that you don't appoint, in our view, would be fair, because if you appoint, you are basically, in breach of your duty to provide a safe workplace to this employee.
Okay, so are there any other options that you can mention, Luca?
Yeah, I think the assumption is, and I should have probably mentioned this earlier, the assumption is when you interview, you have a vacant position and you go through the interview process, the assumption is, for purposes of our discussion, that the person, the job applicant with a comorbidity is the best suited candidate. So there's no other, you want this person. I mean, you won't go through all of this whole process and go through all these efforts if the person with a comorbidity is not the best suited candidate. If that's not the best suited, that would be the reason for not appointing. You will go for another candidate. But if this person is genuinely the best suited, and you've gone through this whole process, you went to the doctor recommended these special measures, you can't, for whatever reason, implement these special measures, you need to obviously disclose to the employee, be transparent to say, or not employee, job applicant, and say, this is the reason why we are not, we are not appointing you is because as the employer we can't provide you with a safe workplace. That's as simple as that. But if it is a case where you genuinely need this person, you need to employ this candidate, then one can possibly consider, discussing with the candidate the option of the job candidate or applicant indemnifying the employer against claims in this regard. In other words, signing an indemnity form to say, I indemnify my employer. I give informed consent that going forward, I'm happy that the special measures that are in place, albeit different to what the doctor recommended, is in order going forward.
Sure.
But I would recommend that because there is different opinions on the indemnity that I've just discussed. So if you are in a situation as the employer and you consider this indemnity that I just spoke about, I think you should definitely obtain legal advice in that regard.
Yeah. Okay, cool. Thank you so much, Vietja. And thank you to all our viewers that joined us again for our second session. We hope that you will join us for our next. If you do require any further legal advice on this particular topic, please feel free to give us a call, email us. Our details are on our Facebook page. And yeah, enjoy the rest of your Thursday. Keep warm and keep safe on the roads.
Thank you.
Thanks.
Thank you, Farron.